members and to our procedural officer. On my computer it says 9 o'clock. On my watch it says we still have 1 minute to go. So Ms. Nikak, perhaps you could just indicate whether we are live already.
Good morning, Chairperson and committee members. Yes, we are live now. You may continue.
Good, thank you very much. Thank you, Ms. Nikak, our procedural officer. A hearty welcome, honourable members, to you. From what I can see here on my screen, we are quorate and we can therefore continue with the meeting. Also wish to welcome all our guests here today. I'm going to allow the members to introduce themselves, but I would appreciate it if the guests, which seem to be quite a long list, if they could introduce themselves the moment they take part in the proceedings or when they present. Honourable members, can I just quickly indicate this is the 9th of February 2021. It's the Standing Committee on Agriculture, Environmental Affairs and Development Planning, and we are here to consider the Western Cape Land Use Planning Amendment Bill. And with that, honourable members, I would like to give each of you an opportunity just to introduce yourself by just stating your name and your position. Thank you.
Morning, Chair. Deirdre Bartman, member.
Welcome, Honourable Bartman.
Morning, Chair. Matlodi Maseko.
You're most welcome.
Good morning, Chair. Brett Heron.
Good morning. Most welcome, Honourable Heron. I believe that deals with the list of honourable members that I can see on my screen. Good. Then, honourable members, just before we start with the item today, I just want to say last week a point of order was raised by Honourable Bartman, and I indicated that I would rule on that point of order at our next meeting. Now, it involved Honourable Marais, who, as you know, joins us as an alternate to Honourable Heron, with Honourable Heron being part of this committee when we put our hat on for planning and development, environmental affairs, and then with Honourable Marais being here for agriculture. So I expect them to deal with that matter then tomorrow in our meeting, when we will be considering the safe and dignified transport of farm labourers. And with that, honourable members, you know the rules of engagement for our video conferencing by now. You also know that this meeting is streamed on YouTube, and therefore I would like us just to keep in mind that this is a public meeting. We've received a number of apologies for this meeting, the first being that of Minister Anton Bredel, then also the Head of Department of Environmental Affairs and Development Planning, Mr. Piet van Zyl, Mr. Anwar Gafoor, the Acting Chief Financial Officer of the Department of Environmental Affairs and Development Planning, and then also Dr. Matthijs Oorendal, the Communication Officer of the Western Cape Provincial Parliament. And then late last night, I also learned that Mr. Gerard Gerber has got another commitment that has come up, and that he also submitted his apology. Ms. Nikak, does that deal with all the apologies?
Chairperson, I've just received an apology from Member Pat Moran. He will not be able to be in this meeting today.
Good, thank you very much. Thank you for informing us of that as well. Honourable members, as I've indicated, this morning is meant for us to be briefed by the department on the amendment bill to the land use planning ordinance, and then obviously we are able to put some questions to the officials, and then secondly, for us also to decide on the public participation process in therefore receiving comments from the public regarding this amendment, where they would be able to share their ideas, support or objections regarding this amendment bill. Honourable members, and therefore unless anybody of you indicate that you would like to speak, and I've got my participants sub-screen open here as well. So if you would like to participate, please just raise your hand. I'm going to hand over to the officials to deal with that. If you would be so kind, I think it's Mr. Munro that's going to lead the presentation. If you could just give me an indication, and welcome, and you're free, we're all ears. Thank you.
Good morning, Honourable Chair and members. Yes, indeed, I will take you through a presentation, Chair. With me today, I have myself, Cobus Munro. Of course, I am Director of Development Management at the Department of Environmental Affairs and Development Planning. And with me is Mr. Theo Rebel, who is also in my directorate, assisting us with planning and legal matters. And then also assisting us today from the Office of the Premier Legal Services, Ms. Clara, she is in the meeting. Clara Williams has joined us already for any questions from a legal point of view. So thank you very much, Chair. I feel a little bit almost embarrassed, but we have a number of slides, 20 of them. It sounds funny to have 20 slides to explain why to take out one sentence out of an act, but I think it is a significant sentence in the act, and I think we should spend the time, approximately 20 to 25 minutes, if that is good, Chair. That we just go through the story and how we arrived at this point and why it is necessary and what the impacts of this amendment would be. I have prepared, as I said, 20 slides. If, Chair, you want me to go faster than that, I can maybe try, but can I proceed on that basis?
Please do. Would you be able to beam the presentation onto our screens, Mr. Munro?
I will certainly try, Chair, and
while you're doing that, can I also just extend a special word of welcome to some of our guests, including the representatives of SALGA, because as honourable members will see, this change affects particularly our local governments. Thank you, Mr. Munro. You may continue.
Can you see the slide, Chair?
It's on my screen. Thank you.
Good. Chair, so we're talking about a land use planning amendment bill here today, and I would just like to take you through the reasoning, why it became necessary to do this at a fairly urgent basis. But I will take you back just a little bit, because this standing committee we have not had the pleasure to deal with planning matters in front of this standing committee. You will see that it was actually towards the end of the term of the previous standing committee that all these acts came about. So allow me maybe just to start off by giving a little context where we're at this point in time. The project committee on the LUPA amendment bill, that's our team there, Chair. I just want to show you that we're quite a big team that work on the amendment of the bill, and I'll show you now that it's not only this item that is in front of you today. In fact, we are looking at more changes, but I will get to that just now. This is just a slide, Chair, to put the context of which act we're actually talking about today. You will recall maybe that we have in planning terms, or legislation that regulates land use planning, we currently have 3 acts or 3 spheres of acts in South Africa, starting at national level with so-called SPLUMA, or the Spatial Planning and Land Use Management Act. We also have the Local Government Municipal Systems Act there that governs or regulates certain aspects of planning, mainly the SDFs. Then at provincial level, we have a Western Cape Land Use Planning Act, which is what we're talking about today. And then, of course, municipalities all have their own bylaws on land use planning. And all these acts, all 4 of them, have carefully been aligned so that they work together. And it was quite a process up till 2015 to get that done. So we are amending the middle one, Chair, today, which is the Western Cape Land Use Planning Act. And I'm showing this that we must just ensure that these acts still stay aligned once we've done this. The reason I'm putting this slide up, Chair, this is the process by which these acts were introduced between July 2015, when the first municipality was the City of Cape Town, transitioned from those acts on the bottom left-hand corner, which is that whole list of acts which were the acts that governed our sector for many, many years, to this new system. And as you can see, it happened on a staggered way, with the last municipality being Oudtshoorn, introducing their act in October 2016. So this happened over a period of 16 months, each month a different number of municipalities introducing the system. So what we've got now, Chair, is that we are basically now between 5 and 6 years after the implementation of this new system between 2015 and 2016. And it has always been our intention to give this new dispensation a few years to settle. And during that 5 or 6 years where we're at the moment, we kept notes of things that do not work as well as they should, and we should acknowledge where things can be improved. And that's what we're busy with now. We're looking at a review of the entire LUPA, and we already commenced in 2019 with that process. And there will be quite a number of sections that we would like to improve, basically to reduce red tape and regulatory burden on our system to make things faster and more efficient. However, so with the onset of the COVID pandemic and the national state of disaster, we had to turn our attention to one particular challenge that we've identified, that now cannot wait for the rest of the process, because the rest of the process is still going to continue later on during the rest of this year. And I refer to it as registered mail, although I will show you now that it's more than just registered mail, but effectively it is the ability of our South African municipalities to currently use registered mail under the lockdown regulations that is hampering service delivery that we had to deal with immediately, Chair. So what happened was, during the national state of disaster, municipalities faced a challenge as they were not able to comply with LUPA, and I'll show you now why, of giving notification when dealing with land use applications. The provisions of the section we're talking about here today is section 44.2b of LUPA, effectively limits municipalities to give notification using a registered post and a number of others, which is leaving a notice on the person's residence or business, or posting the notice on site. And as a result of the pandemic, I think you would appreciate that it was almost impossible for municipalities, or at least extremely difficult, to comply with that section, resulting in land use applications effectively grinding to a standstill across the Western Cape, in fact, across the whole country, Chair. So we had to do something urgently about this, because there were absolutely no applications being approved, and we'll get to the impact just now, Chair. So our Minister of Environmental Affairs, Development and Planning, Minister Padel, on 20 May, then gave an exemption so that municipalities do not have to comply with the section. And as you can see at the second last bullet on the page, our Minister had to give that exemption 3 times already. So on 20 May, he gave the first 90-day exemption. And because the Act only allows that exemption to last for 90 days, a second and a third authorization had to be granted on 18 August and on 16 November. And in fact, next week, Minister will have to grant yet the 4th one. So we have done this emergency exemption so that municipalities are able to actually proceed with service delivery, Chair, and I'll show you now what that is about. So this is the section, and it's a lot of words on the screen. I apologize for that, but I need you to see the context. So section 44 of the Land Use Planning Act deals with the serving of notices, and this is a very important aspect when you have to serve a notice on a person that is affected by an application. The Act specifies how that should be done. And what this subsection 1 does, it lists a number of applications, A to G. I'm not going to go through them, but those are the different kinds of applications that a municipality can receive for development. And basically what the Act says is once you receive an application, one of those, then you have to give notice to affected parties in a certain way. And subsection 2 deals with that way. That notice, so Chair, let me just check here. Are my slides still showing on your side? Am I not running ahead of myself?
We can see the slide.
Thank you, Chair. So that notice that subsection 1 speaks about, Section 44 determines that it must be served in a particular way. A, it must be served on persons whose rights or legitimate expectations will be affected. But then B, that is the part that this whole session is about, Chair. It must happen in accordance with Section 115 of the Municipal Systems Act, and I'll show you that extract from the Act just now, and then C in at least 2 of the official languages. That stays the same. So A and B still stays the same. It's just the way in which these notices must be served in accordance with the Municipal Systems Act that we need to remove. So the proposal is to remove that red section from the Act, and we will show you now what the effect of that would be. This, Chair, is, and again, it's very busy, I apologize, but this is the Section 115 of the Municipal Systems Act that deals with serving of notices. And any notice or document that is served on a person in terms of this Act or by a municipality in terms of any other legislation is regarded as having been served. When it happens in one of those 5 ways that we have highlighted for you, Chair. So I think these things are very old. They even come from the 1974 municipal ordinance. So we've come along with these methods of notifying persons for many, many years, Chair. So delivered to person, left at the person's place of residence is another way. And then the number C is posted by registered or certified mail. Chair, I would guess that probably for about the last 100 years, that is how we officially communicate with people. It is a way that you can ensure that people get the mail because it's registered, and it's also for the municipality, they can prove that they've in fact dispatched it if there's a conflict or people claim that they have not received the mail. So that has been the go-to method for many, many years. And then D is if you can serve it on an agent, or E, post on a conspicuous place. So municipalities effectively were using registered post for all these years, Chair. And what happened during the COVID period is that effectively became a problem. So So Section 44(2)(b) in LUPA cross-reference to the Municipal Systems Act and effectively determines that those methods are the only methods that you can use. And so the minimum requirement in our LUPA, in our Land Use Planning Act, is regarded to be excessively restrictive because now you cannot use other methods. Now for many, many years, and I guess probably 100 years, that was no problem because our post offices functioned properly. There was no COVID, and that was fine. But suddenly we now faced with a situation that our post offices are not functioning as they possibly could under the COVID conditions, and people do not want to stand in queues to go and collect registered mail. They are scared of this illness. And the post offices for a long time were closed. So more modern economic and more effective methods of direct notification, including the methods in the Electronic Communications and Transactions Act, is currently not permitted by Section 42(b), and that is what we're trying to achieve here, sir, and I will show that just now. So the problem with the post office was obviously as a result of the COVID pandemic and the national lockdown. And for quite a number of months, between March and May, it was not possible to conduct public participation because these methods were not available. So we need to amend our Land Use Planning Act to enable municipalities to use other methods of notification, which would then result in them not being in non-compliance with the Land Use Planning Act. So we need them to still communicate legally. This is just, Chair, an extract from the City of Cape Town's Municipal Planning Bylaw. And again, I don't want you to read everything. I just want to, by way of example, show you how this is going to work. You will see that the first 5, Roman 1 till Roman 5, if you can just look at my blue insert there, of direct notification, is exactly the same as the methods in Section 115 of the Municipal Systems Act. So here the Municipality of Cape Town are using exactly the same methods, and also the registered posts were used for as long as we can remember. But if you look at the bottom there, the City of Cape Town bylaw also includes other methods that you will not find in the Municipal Systems Act. And it says there email, fax, and other forms of electronic communication. So we are in the electronic era, and emails and WhatsApps and all sorts of electronic platforms that are available through the Electronic Communications and Transactions Act, although it sits in the bylaw of the City of Cape Town, and in fact all the bylaws of our municipalities in the Western Cape. Currently, the Land Use Planning Act does not allow municipalities to make use of those methods. And we need to rectify that, Chair. And we had to achieve that by asking Minister Bradell to give us exemptions for 90 days, and we're already at the 4th one. And it shows you municipalities are in fact using those other methods. So the amendment bill as published, it is really simple. It is merely the removal of that sentence. So Section 44 of the Western Cape Land Use Planning Act is amended by the deletion of paragraph B of subsection 2. And that is what I've just explained. The memorandum on the objects of the Western Cape Land Use Planning Amendment Bill also in summarized format explains what I have just explained to you, Chair and members. So I'm not going to go through this. That is the content of the slides that you've just seen. So what would be the effect if we give effect to this amendment? So the proposed deletion of that section will enable municipalities to themselves decide which communication methods to utilize to effect direct notification. It will still not absolve municipalities from compliance with other legal prescripts, which is important. For instance, the Land Use Planning Act have other prescripts, the Spatial Planning and Land Use Management Act have other prescripts, and most importantly, PAJA, or the Promotion of Administrative Justice Act, still requires you, when you notify people, to do it in a certain way. And that will not be, we will not absolve municipalities from that. So in whatever method they use, Chair, they will still have to ensure that they still comply with those fair administrative practices as contained in the Promotion of Administrative Justice Act. But it will enable municipalities to utilize alternative measures to ensure direct notification without being non-compliant with the Act. So we had to do this because our economy was taking such a hit, Chair, during COVID. We simply had to get land use applications up and running again. And the lockdown regulations did not allow municipalities to continue with service delivery in terms of the processing and approval of land development applications. So we simply had to find a way. The post office was not fully operational during all the levels of lockdown. In fact, for a very long time, the post office was not dealing with registered post at all. And I want to guess that registered post is still not up and running as the way it should. We're hearing lots of reports of registered posts still not reaching the target audiences. During this time, the public was reluctant to visit the post office. As I said, in some instances, it was closed even. and long queues and fear of contracting the virus. So we had to find a way to continue with service delivery. That was not negotiable. And the authorizations granted by our minister provided an interim solution and enabled municipalities to process and finalize development applications. But now we need to amend this, Chair, permanently, because I suspect we will never fully go back to registered post again. Even after the pandemic, the age of electronic communication is with us, and as municipalities start using those alternative methods of notification, some of them may return to registered post, but we suspect that many of them will not. The impact on the municipalities, of course, this allows municipalities to perform their constitutional mandate and ensure efficient and effective direct notification. It provides municipalities with more flexibility to employ the mechanisms already set out in their bylaws. There are no negative financial implications for the province or the municipalities as a result of this. In fact, it may even improve the financial implications of processing applications by municipalities. And as I said, Chair, many municipalities have already migrated to integrated electronic communication platforms. The transition has already been implemented in larger municipalities, some even small municipalities. And the impact on communities and the public is also an interesting one, Chair. Registered mail has for a long time not been an efficient and effective means of communication. I think we have to acknowledge that as well. So it is just as well that we revisit this method of communication. In reality, the use of registered post yielded very poor results, and we've had reports that only between 40 and 60% of registered mail is ever collected. That's even before the national state of disaster. So although it was a convenient way of communication and a very good way of ensuring that you can prove that you have communicated with somebody, in reality, it's only about 50% of people actually got that mail and made use of the opportunity to participate in a process. I think these days people are really reluctant to go pick up registered mail anyway, because it's mainly fines or legal problems, so you don't want to look at it. Whatever the reason is, the hit rate, if I can call it that, was very poor, Chair. We expect that the electronic communication methods will result in much higher percentage of affected parties being reached. And there are now more opportunities for interested and affected parties and communities to participate meaningfully whilst legally recognizing electronic communication as a formal communication notice mechanism. Developers, of course, I think that speaks for itself, Chair, but development applications could now be processed once the Minister gave the exemption and commenced irrespective of the lockdown regulations. It was really important for our province and our country that developers proceed with development applications and get their approvals so that we don't lose any more jobs and that they could retain staff. The other thing is developers can also assist with electronic communication efforts. The legislation allows that a municipality can require an applicant to assist with the dissemination of information through the electronic communication efforts. And in fact, the private sector often can do that much better than the municipalities or we can. And without the approval that we're talking about here today, Chair, and the Minister's exemptions, the construction industry, building industry, infrastructure, housing sectors would all be really heavily impacted, including all professionals associated with these sectors. I think when we look back at the year that's passed, Chair, our municipalities have done incredibly well. City of Cape Town specifically, if you look at the numbers of applications, they have not fallen behind. They, with building plans or land use applications, they have made sure that there are no backlogs anywhere at our municipalities. And it was mainly as a result of this, Chair. Otherwise, if we haven't done this, we would have had serious backlogs and with devastating effects on this sector of our economy. Last two slides, Chair. So the process to date, we started, as I said, last year with this process in the bigger process of LUPA amendments, when we realized that we had to do something urgently about this specific section. And on 3 July, we got in principle Cabinet approval for the drafting of the amendment bill. For August, the Cabinet approved the publishing of the draft amendment bill for public comment for a period of 10 days because of the urgency. And on the 10th of September, apologies, Chair, 10th of September, that notice was placed, and you see the advertisement dates there. And it was placed in the media, August, the Burger, and then also we at the department have a very comprehensive list of contacts that we could communicate simultaneously with all the mayors, municipal managers, our planning heads, planning consultants, and representative bodies, such as the South African Association of Consulting Professional Planners, Geomatics Institute, Western Cape Property Developers Forum, and other bodies. So we communicated with all of them. So on the 24th of September, at the closing date, there really wasn't much. I think as everybody realizes that this is needed and this is important, and only very few people commented. You can see the departments there at the bottom of the page. So the only really reservation expressed was that the deletion of the section may result in too many electronic communication options. You know, that the options are now too wide, and that we should regulate that space, and that the form of communication must be defined to ensure that the messages are not delivered to junk folders, incorrect places, numbers, etc. And that all expedient methods should be set out, and that electronic communication to a confirmed email address, etc. The City of Cape Town requested further amendments, which we will deal with in the rest of the process, Chair, but not here today. So the response from our department and the Department of the Premier Legal Services was that LUPA's framework legislation, which aims, amongst others, to assist municipalities to perform their land use planning functions. And in terms of the Constitution, have the executive authority in respect of that municipal planning function. LUPA again specifies the methods that may be used. The amendment will not have an improvement on the current text and will again unnecessarily limit municipalities. So, and that province shouldn't prescribe to municipalities what methods of communication they should use, and that they can use the Electronic Communications and Transactions Act as already provided for in their bylaws. So on the 27th of October, we submitted that report to Cabinet, who then considered and approved the introduction of the amendment bill to the Western Cape Provincial Parliament, which happened on the 9th of November last year, the introduction of the bill to the Provincial Parliament. And as you know, on the 11th of December 2020, the provincial notice was published advertising the amendment bill again in the Provincial Gazette. That closing date was 10 days ago, Chair. That's where we're at this point in time, and we are available for any questions. Myself and Theo Rebel, as well as Clara Williams from the Office of the Premier.
Good, thank you very much, Mr. Munro. I hear some feedback there. Hopefully it will not disturb other members. I'm just wondering, Mr. Munro and colleagues, if you would just allow the representatives from SALGA, if they would just like to make a brief presentation or input at this stage as well, before we go over to questions from members. Is there anybody from SALGA that would like to indicate their support or not for this proposed amendment?
Good morning to all the members, also good morning to guests. Chairperson, thank you for the opportunity. SALGA did take part in this, although it wasn't very, let's say it was slight. But be that as it may, we did send a message out to all our municipalities. It seems to me it was only the B and C municipalities. Well, then most probably only the B municipalities, because I don't think the C municipalities really are all that interested in this. And we got feedback from Mossel Bay and from Overstrand. And in general, what it pertains to is that they support the amendment, and they support it along the same vein as the suggestions that were made by Province this morning. So it seems that from municipalities in the Western Cape, there's no objection to this amendment. I can read to you the specific wording of the municipalities, but I don't really think it's necessary. I think the presentation done by Province this morning is very thorough, and I fully agree with them as to what was said this morning. The post office is simply just not effective anymore, and now during COVID, they also pay out the SASSA grants. So you can take a look at any post office. You will find a tremendously long queue. And many of those people, and this is a general statement, do not wear masks. So it's not a safe environment, and therefore people don't use it. And registered mail has just become completely ineffective.
Thank you.
So I fully support Province in this. Thank you very much.
Good. Thank you. Thank you, Mr. Coetzee. Members, over to you. Any questions from your side to Mr. Munro and his team? I see Honorable Bartman's hand. Can I get some more hands at this stage? Only Honorable Bartman. Please proceed.
Thank you, Chair. Chair, firstly, I just want to say thank you for the department for bringing this. It seems that using of email and things like other electronic means will also save municipalities money, I think, and assist with cutting red tape. And as was indicated previously, we do have a National Electronic Communications and Transactions Act, which was adopted in 2002, I think. So it's not like we're reinventing the wheel. We're simply allowing the wheel to be used in a more effective way. I do have a suggestion for the department and just one question. My suggestion to the department is that they do a roadshow. It doesn't need to be a physical roadshow. It could possibly also be electronic roadshow based on, the type of what we're introducing at the moment, to assist municipalities with specifically understanding the requirements within the sections of the Electronic Communications and Transactions Act, which was adopted nationally many, many years ago. And the reason I ask this, Chair, is even if municipalities have the ability to do this on their own and they have the choice on what type of means they need to use, I don't think all officials would necessarily understand what retrieval and sending of information and maintenance of the integrity of the information and good email electronic management systems, how those type of things necessarily work. Because when you use electronic communication, if I remember correctly, you need to also have a system for auditing. So similar how you would, for example, keep paper documents for a certain amount of years, for example, to cross-reference and check old things, you would need a system for storing, for backing up, for checking and such maintenance and communications policies possibly. And I do think that municipalities will need assistance with such in this regard if they don't have it themselves. Further, I wanted to find out with electronic communication, and given that even in the National Act, there can be some confusion as what is retrieval, what is the sending of information, what types of information you're allowed to use. Is WhatsApp official? Is it not official? I do think that if this is then passed, that the department would have to almost draft a guide to electronic communication, and specifically electronic communication for official documentation. We have we are now in 2021, so it's wonderful seeing amendments like this. And companies have been using it, SARS has been using it, South African Reserve Bank has been using electronic communications. It's not new. But if we want to completely want to move into the 4th industrial revolution, and more likely the 5th actually, which we are more likely in, then we need to make sure that we are bringing everyone to the table. We're not leaving any municipality behind, and assisting with the right to information and to administrative justice. Thank you.
Thank you, Honourable Bartman. My recollection is that that was more of an input than of a question specifically to the department. It seems to me as if you're in full support and have very little concerns at this stage. Can I just ask any other questions, any members with questions to the department? If not, can I just ask Mr. Munro, sorry, Honourable Heron, please go ahead.
Yeah, thank you, Chair. Not really a question, but I think this is an obvious amendment that needs to be made, and I think that we should support it. I do want to just caution that we look at those concerns that were raised as were presented about how wide electronic communication is. Does it include Facebook and Twitter and WhatsApp? So I think that does need to be managed in a way that we can be assured that the recipients of those notices do in fact receive them and cannot deny that they didn't receive notification. So that's the only comment I wish to make. Thank you.
Thank you, Honourable Heron, and mine links on to what you've just said. Mr. Munro, the section 44.2, even if that B part is deleted, still reads that a notice must be served on each person. Now, how important is it for a municipality afterwards to be able to prove that it has served that notice, or that it has tried to serve that notice on each person whose rights will be affected? That's my first question. The second one, I must say, and I know this is not your focus now, but it will also affect the communication means that will be used, is how do you define each person whose rights will be affected? And perhaps I must just declare my particular gripe here. What I often see is where property borders onto public land, that people then seem to deviate with applications quite easily, because it seems as if, you know, the ward committees are not informed, or they don't worry or to comment or anything like that. And that quite often people that border onto riverbanks, onto public open spaces, etc., seem to be allowed some uses of their land which don't always, I think, if it was bordering onto private land, would not always be allowed. And therefore my question is just, how far do you interpret that thing of a person's rights? Isn't each and every ratepayer in a town affected by certain developments or certain land use changes? So those two things, how important is it to prove that you've at least tried to serve something on a person? And secondly, how wide is that net of people whose rights will be affected if that matter is approved? If you could just help me in that regard. Thank you. Sorry, and before you respond, I see there's also the hand of Honourable Maseko. I presume Honourable Heron is going to take his hand down unless he wants to come in again.
Thank you very much, Chairperson. I just have one a question of, or maybe if I can hear from the department, if they can add on the info that they have to give to us. I want to find out, because of the lockdown, they sort of implemented the 90 days for the municipalities in making sure that the services are continuing. Do they do the sample checking of this? Because in a way, they implemented temporarily for the municipalities to implement the processes. In sample checking to check if this amendment for this bill it is going to work or not, and if they did that sample, where did they do the sample? Which municipality already has been active in implementing the electronic services? And another one, it will be what is it that they feel we have to tweak, or they have to tweak this amendment for it to be clear and for the municipalities to upskill themselves in implementing this, because it's another thing that it will be needed of the capacity, and also making sure that the municipalities' website up and running and are maintained for the people to can know that what is it that is happening. So electronics, fourth industrial revolution, has to be up and running in our municipalities. And it's one skill that we have seen that it's a little bit lacking. If you can check all municipalities, their website the others has been out for about 8 years, others 5, others 2, others 1, but it's one of the side that we have to make sure that that is up and running to update for the communities to know what is happening, what is coming on that side. Thank you, Chair.
Thank you. And Honourable Heron again. Honourable Heron, I see your hand is still raised, or raised again. It seems as if we've lost connection with Honourable Heron. Mr. Mandro, over to you for your responses.
Thank you, Chair. Going back to Honourable Bartman's comment, thank you very much for that comment and the suggestion of a roadshow to assist our municipalities with the Electronic Communications Act and the methods that are available. I think that's a good suggestion, sir, and we could team up with our communications colleagues and see to put together something like that. I think that would be really worthwhile, as we all are now forced to start making use of that again. So with respect to the question whether WhatsApp is regarded as complying with the Electronic Communications Transactions Act, I'm not a specialist in that act, but I believe so, Chair. I can ask my colleague Clara Williams to just come in just after me and maybe give her opinion or input with respect to the Electronic Communications Act. But yes, there are already a number of municipalities that are using WhatsApp to communicate with all the residents in their municipalities, and it's working quite effectively. And yes, to your question, sir, whether it is important that you can prove that you've communicated, that is in fact the crux of the matter. You must be able to show that you have in fact complied with direct notification, in that people did receive that notification. Because just to take you back to the different kinds of communication, you already have the communication to the general public through the press or the media. That remains, and even our government gazette and provincial gazette, that remains to be the other method to sort of, if you like, a shotgun approach to let the whole community know. But when it comes to direct notification, that is when an individual has been identified as being affected by an application or a proposal. And then when the Act does that, it means that you must notify that person directly, and you must be able to show that you have done that. So to answer your question, that is very important, sir. And even through the electronic communication methods that would now be employed, you must be able to show that you've done that and that there is proof that, and the Electronic Communications Act does deal with these aspects, Chair, about when is something served, when is something received, And I believe that those aspects are dealt with the Electronic Communications Act. If there are aspects that, of course, needs further clarification, as suggested by Honourable Bartman, I think it's a good idea that we assist our municipalities with it. I'll come back to Honourable Heron's question just now, but to Honourable Maseku, we have to, after the 90-day approval given by the Minister, the Act also requires of us 2 weeks after, 14 days after that approval, to report to Cabinet on how the municipalities are faring with this. So we have 3 reports, and soon, within 2 weeks from next week, we will have the 4th Cabinet report, and we could obviously also assist this committee with which municipalities. But just off the top of my head, Mossel Bay started with this process first, Chair. No wonder they were elected municipality #1 in South Africa. But they very soon after the lockdown rolled out a very effective electronic communication system with their clients and with applicants, and they actually took the lead in the Western Cape. But a number of other municipalities followed soon thereafter, and so yes, there were municipalities already and still are making use of this, and I suspect, as I said earlier, will not go back to the registered post. Chair, your question with respect to the how do you decide who's affected, that remains a very difficult aspect, and the Act, the bigger process that we're involved in, is going to have a look at that section as well, because at the moment the word adversely does not appear in the Act. In other words, it's not only people who are adversely affected that must be notified. The Act says everybody that is affected must be notified. And that is a discussion that we will still have. In fact, we may have to get legal opinions on it, because there are already legal opinions on whether you only involve people that are negatively infected or adversely infected, or whether everybody in an area that is infected, even if it's positively affected, should be notified of a proposal within your area. But to come back to your question, it then is the administration who is dealing with that notification. It is their job to ensure that everybody, as the wording of the Act is at the moment, everybody who is affected or whose legitimate expectations are affected must be served with a notice. And it could be that somebody is missed, Chair, and that the decision of an administrator is too narrow, and that they have not involved enough people, wide enough. And that is something that could be reviewed. It's something that you can object against. It's something that you could take them up with, because the Act says you must be involved. But it is a decision of the administrator how wide it is. We certainly do not advertise something that happens, in Drakenstein, all the way to Stellenbosch. There is a radius of impacts that you as an administrator must decide. And I fully expect that sometimes those officials make mistakes, that they don't advertise too wide. And it's also the cost element. Coming back to the suggestion by Honourable Heron, I would like Clara to assist me here, Ms. Williams. We discussed this, and we felt that firstly, that the Electronic Communications Act does regulate this space sufficiently, that we do not have to regulate that any further. And secondly, also because this is a municipal planning matter, which in terms of the Constitution belongs at municipal level, and that us from province's side would actually overstep our constitutional bounds if we start to regulate this and make it too narrow again. So our proposal is not to provide minimum standards here, or say that only this method or only that method, but leave that to the Electronic Communications and Standards Act to regulate. And we would not, in fact, propose at this stage, to answer Honourable Maseku's question, whether we need to tweak the amendment bill. Our recommendation, even after that suggestion, is to keep it as it is. But can I, Chair, with your permission, can I ask if Clara Williams can assist us with that question?
Ms. Williams?
Good morning, Chair and members. I'm Clara Williams. I'm a state law advisor at the Department of the Premier, and I've been involved in this project from the start. So maybe just to start with the Electronic Communications and Transactions Act, it has a definition of electronic communications which is quite wide. And if I can just read it to you and the members, please. It says electronic communications means the emission, transmission, or reception of information, including without limitation voice, sound, data, text, video, animation, visual images, moving images and pictures, signals or a combination thereof by means of magnetism, radio or other electromagnetic waves, optical, electromagnetic systems or any agency of a like nature, whether with or without the aid of tangible conduct but does not include content service. So it's a very wide definition, and it looks as though WhatsApp messages, SMS messages, etc. will also fall under that definition of electronic communications, and the Act will then also apply to those ways of communicating. But I would just like to draw the committee's attention to the functional areas in the Constitution dealing with planning. So in Schedule 4, which deals with the functional areas of concurrent national and provincial legislation, there's a reference to regional planning and development. That's in Schedule 4, Part A, and municipal planning in Schedule 4, Part B. And then in Schedule 5, you've got your functional areas of exclusive provincial legislative competence, and their provincial planning is mentioned in Schedule 5A. And this is quite important because if you read the Constitution, you will see that all three spheres of government have responsibilities and legislative mandates regarding planning. So you've got your national planning, you've got your regional planning and development, which is in Schedule 4A, municipal planning in 4B, and provincial planning in 5A. And then in section 156 of the Constitution, it says that municipalities may make and administer bylaws for the effective administration of all the local government matters in Part B. So that also now includes municipal planning. We've got SPLUMA, the National Spatial Planning and Land Use Management Act, which says in its regulations, Regulation 14, that a municipality must at least determine the manner and extent of public participation processes for each type of land development and land use application. And this is where the problem came in, because in terms of the national legislation, municipalities must determine the manner and extent of public participation processes. But we, as a province in LUPA, limited the municipalities in determining the ways in which communication must take place. And it has been proved that this is a very big limitation on municipalities, and that they need to and want to also use other methods that are not set out in Section 115 of the Systems Act. So in Section 41 of the Constitution, which deals with the principles of cooperative government and intergovernmental relations, it says that all spheres of government must respect the constitutional status, institution, powers, functions, etc. of government in other spheres, and must exercise their powers and perform their functions in a manner that does not encroach on the geographical, functional, institutional integrity of government in another sphere. So from our side, it's really important for us not to encroach on these powers and functions that municipalities have in terms of the Constitution, but also in terms of SPLUMA. So we want to take away this limitation so that municipalities can actually perform their duties and powers in terms of the Constitution, the national legislation, and also in terms of our provincial legislation. And then also very importantly, Section 151 of the Constitution, which deals with the status of municipalities. And in subsection 4, it says that national and provincial government may not compromise or impede a municipality's ability or right to exercise powers or perform its functions. So I think this is really, really very important. And then, as the department also said, that LUPA also has a section, that's section 43, dealing with public notification. So you've got your direct notification section, which is section 42, but then there's also a separate section dealing with direct notification and then public notification. So we still have the public notification section providing more details on notifying the public as a whole, but our interpretation also of the Constitution and SPLUMA is that municipalities should decide on how they want to directly notify certain persons. So I think that's all from my side. If there are any other questions I can assist with, I am available here. Thank you so much, Chair.
Baie dankie, Juffrou Williams. Thank you very much. Honourable members, I do not see any further hands of members indicating that they've got questions at this stage, which then leaves me to thank Mr. Munro for his presentation. Thank you very much also to Selga for your input. Honourable members, it leaves us now with the question on how are we going to draw the attention of affected parties, members of the public, to this proposed amendment to the Act. And the department, you are welcome to leave or stay, as we as a committee is now going to consider the route that we intend to take regarding public participation of this proposed bill. So, Mr. Munro, I don't know if you want to speak on behalf of your colleagues, whether you want to stay on.
Chair, with your permission, we would love to stay on as the public participation methodology that you choose. We would like to support the standing committee, and yeah, we're also anxious to hear what route you will follow. With your permission, we would love to stay.
Yes, no, you're most welcome, and hopefully you will also support us in carrying that message out to the various affected parties. Good, honourable members. In the past, we've often made use of a variety of means, and I was wondering whether Ms. Niekerk could just perhaps again take us through the various options, and then for us to decide which of these options we would like to pursue, if not all. So Ms. Niekerk, perhaps if you could just come in and also perhaps inform us of the budgetary implications and whether we do have sufficient budget left, either in this financial year. It seems to me we've got a lot of legislation to deal with in this calendar year. So Ms. Niekerk, perhaps if you wouldn't mind just helping us in terms of the call for input and comments.
Okay, that's fine. Thank you, Chairperson. Just in terms of the committee's budget, I'd just like to inform the committee through you that the budget has been adjusted. So the committee's original budget was 132,000. It's now been adjusted to 207,000 Rand. So the available budget to date until the end of March is 100,453 Rand. So in light of that, Chair, the committee's budget is fine. We have enough money available for the public participation process of the bills. All right.
Thank you. That is particularly for advertisements, but I know we've also used other means of communication in the past.
That's correct, Chairperson. Well, the committee now needs to decide if it will conduct a public hearing. We did not conduct public hearings with the past bills. Instead, the committee then decided to call for verbal presentations and written submissions. So interested persons and organizations were then invited to submit written submissions and then request to make a verbal presentation on those written submissions to the committee. And particularly, I refer to the Center for Environmental Rights last year that followed this way of submission. And then the committee may also then call for oral submissions. We did that in the past. And when I say oral submission, I mean the WhatsApp number that was made available. However, this method of communication, the WhatsApp, was not used at all by members of the public when the committee created this platform, when it dealt with the 2 NCOP bills. The committee then also, in order to create public awareness, it advertised in various print media as identified by the committee in a meeting. It also advertised on social media, so all information, contact name and address for inquiries it was uploaded onto the WCPP's Facebook page, Twitter and Instagram, and then the bills were also available on the Western Cape Provincial Parliament's website. What we also did in the past was we did stakeholder-specific letters informing specific stakeholders of the pending legislation and requesting them to submit comments, and specific stakeholder letters included municipalities. And then, Chairperson, in terms of the LUPA Amendment Bill, the Department of Environmental Affairs and Development Planning have shared with us the names of specific stakeholders, which include SALGA, the municipalities, all the Western Cape government departments, the South African Association of Professional Planners, the Western Cape Property Developers Forum, the South African Geomatics Institute, ratepayers associations, amongst others. And perhaps a proposal could be that all these stakeholders could then be listed and stakeholder letters then be sent to them. That was the process that we followed with the last 2 bills. We did say that the public education and outreach section, they are available should the committee decide that they want to make use of that department's mandate, which is to inform stakeholders on the content of the amendment bill, and then they also assist the stakeholders in making submissions. And then also, if the committee feels that it needs additional research to be done on the bill, the amendment bill, they are welcome to indicate as such. And then also our legal advisor is present in this meeting should the committee have any questions regarding legal clarity. Thank you, Chairperson.
Thank you. Thank you, Ms. Nikak. Before I hand over to the members for your comments on this, Ms. Nikak, you've dealt with a vast array of options and means of communication or role players that you believe we should be informing of this amendment bill. You can assure me that we've got the administrative capacity to communicate with all of these role players, and I presume that is already an indication of the ease of electronic communication. But before I hand over to Honourable Bartman, just your confirmation, Ms. Nikak, that we would be able to contact all these affected or parties or role players.
I confirm as such, Chairperson, we do have the capacity to do that, yes.
Good, thank you very much. Honourable Bartman.
Thank you, Chair. Chair, I'm not going to comment on the budget and administrative aspects because since public participation is required in terms of the national provincial constitutions, I don't think it's too big of a problem that Parliament would assist us when assistance is needed. Regarding the public hearing and the options for that, I just want to check. I thought a virtual public hearing is the same as oral submissions, but perhaps I'm incorrect with my interpretation. And if I could just get some clarity on that. If it is not the same, my suggestion then is we need to have a public hearing, but do it virtual the same way we do MS Teams for our meetings. And that can include the oral and the written submissions the same way we do on NCOP bills, for example, and national bills. And I also feel, Chairperson, we should continue to use the WhatsApp because whether or not someone makes a submission on a bill will depend on the level of controversy of the respective bill. And Personally, I would prefer us giving the public more appropriate options rather than less. And I believe that as stakeholders start becoming more accustomed to the digital age, that we will hopefully see more use of these types of platforms in the future. And it gives the option to someone who says, I struggle with writing an email. Let me send in a voice note. Let me say my name and my surname, which municipality I'm from, my ID number, and say this is what my concern is. Because that person doesn't necessarily know how to read and write. And we do need to start encouraging such platforms more. And that is my view. Thank you, Chair.
Thank you, Honourable Bartman, and I personally support that view. Honourable Maseko. Honourable Maseko, you can continue. You're still on mute.
Okay, thank you very much. Chair, I just want to hear from Shireen, maybe she can help me. In the past, when we had a bill, we will ask the outreach department to go, the public education to go and sensitize the communities or the stakeholders about the bill that is coming so that they can have an understanding about that bill to be able to contribute. In these circumstances, since the lockdown, I do understand that things are not the same, but that service, I think sometimes is needed. How are we going to go about to make sure that that happens, or is not necessary for now, as it's just the one sentence of the amendment to the bill, so that we can get clarity of attending the basis of public participation? Thank you, Chair.
Thank you. Ms. Nekak, would you like to respond now?
Chairperson, I think it is best for our manager of the Public Education and Outreach section. He is present in the meeting to respond to Ms. Maseko's question.
Thank you.
Good morning, Honorable Chair. My name is Themba Keswa. I'm the manager PEO. To answer the question, I can just say because of COVID-19, like you've just said, it becomes a mission now to have a face-to-face kind of a meeting. So what we've been doing in the past since the COVID started is simply to sensitize the stakeholders about the upcoming legislation, inform them that there is a legislation that is coming, send emails and ask them to participate in the manner that is allowed, but only virtually or by sending a message back to us or a response back to us. So that's how we've been doing at this point. But the face-to-face kind of meetings have been not good at this point. I don't know if I'm answering your question correctly, Honorable Member.
Thank you, Mr. Keswa. And I presume that when Ms. Nekak informed us that the necessary capacity exists, that she was also thinking of involving you in that process. So, honourable members, just to honourable
Chair,
Maseko,
I've got my hand up. Yeah.
Yes.
Okay. Chair, I do understand the COVID-19, but I think there are other innovative ways that we can do that to have the explanation. Like if the public education, Mr. Keswa can go to choose the radio station, the community radio station, to go and explain what the bill or something to that effect that they can explain. It's not going to be the physical contact with the communities, but it will be spreading the gospel about the amendment of the bill and explaining to the people what does the bill entail, what is it that it's saying to them. So we need to also embrace the new norm to say we need to think out of the box, because the fourth industrial revolution, anyway, it's here. They have to think that way, that they don't have to pack their bags and go from area to area. They have to use another spheres or another means that are out there for them to be able to run the department. So I don't think what Mr. Keswa was saying, that it will serve the purpose of what they used to do, which it was a brilliant thing to do as we do the bills. Thank you, Chair.
Okay, good. Thank you, Honourable Maseko. Honourable members, it seems then to me, what I'm hearing from you is that we use the traditional ways of inviting the public to comment on the bill, but that we also continue and include some of the more modern ways, which include then, and I particularly like the WhatsApp voice message, as it also allows for this, certain types of disabilities. And then Honourable Maseko's proposal that perhaps even a short video clip explaining it, or a voice clip that can be sent to radio stations. And I presume that it would also include a media statement on behalf of the committee, just from our side, explaining the proposed amendment. I think the advantage is that this amendment is a fairly brief one, and it, you know, people would be able to share their ideas quite easily on this. Ms. Nikak, do you need any further detail? Do we need to specify which newspapers? I would think that newspapers that cover the province would be sufficient, that we then don't need to cover all the community newspapers, as it would be very difficult to decide which are we going to include and which are we going to exclude. But I'm open, Ms. Nikak, for your ideas in that regard as well.
Thank you, Chairperson. I think in terms of LUPA, based on the content of the bill, the committee needs to decide on print publications. And you're quite right. I would propose then, or suggest, that the committee just considers using mainstream newspapers like the Cape Argus, this Weekend Burger, and the Weekend Argus. But ultimately, Chair, the committee needs to decide on that. Thank you.
Thank you. That is the proposal currently, members. Can I get an indication of whether that is supported?
Yes, Chair.
Yes.
Good. Thank you. Thank you
Yes.
very much. Thank you, honourable members. Ms. Nikar, can we then step off this item regarding the public participation?
We may, Chairperson. Thank you.
Good. Then thank you. Then, honourable members, that brings us to the next point on our agenda, which is the consideration of minutes. And this is then the minutes of the, sorry, I'm scrolling to find the date of those minutes. Ms. Nikak, please help me.
It's the 2nd of February, Chair. It's up on the screen.
Good. Thank you very much, ma'am. Honourable members, I put to you page 1 of those minutes, then page 2, good, and then page 3. Can I get an indication of whether you find that a correct version of our meeting?
Support, Chair.
Thank you. I've got a proposer. Further support for this?
Yes, support, Chair.
Good. Thank you, honourable members. That is then adopted. And then, honourable members, just in terms of our program going forward, I've also just received a message from our procedural officer that there is a piece of legislation coming our way from, again, the NCOP in terms of can I call it land use, land restitution? I think it's the Ultra Bill, and that their attention has now been drawn to the fact that there's a constitutional deadline. I presume the court has found certain aspects of this legislation to be unconstitutional, and has given the National Assembly limited time to correct this. And it may be that we will have to go back to programming authority because that's quite a strict deadline that they are looking at. I think we've got until March just to finalize that. So I don't know if they eventually will have to approach the Constitutional Court again for a postponement, but there is some pressure from that side for us to act quite quickly on the ultra bill, which I presume will be referred to this committee as well. I'm not clear whether it is going to be us. I see in many respects it seems to me in other spheres of government that it's a public works that deal with legislation dealing with land affairs, etc. Good. And then, honourable members, I don't know if there are any other matters that you would like to raise before we go over to a word of thanks and for the meeting to adjourn. I see a number of hands. Ms. Maseko, Honourable Maseko, and then Ms. Niekerk, who perhaps would just like to take us through our program going forward. Honourable Maseko.
Thank you. Yes, thank you, Chair. I think Ms. Van Niekerk, if she can go forward, because I wanted to talk about tomorrow's meeting, tomorrow's agenda, and I suspect she's going to talk about today's. So if we can allow her to go first, if it's okay with you, Chair.
It's fine. Thank you, Ms. Niekerk. I think Ms. Niekerk was also going to just speak about tomorrow and remind us about tomorrow's meeting. Ms. Niekerk.
Thank you, Chairperson. I actually just want to refer you to the upgrading of the Land Tenure Rights Amendment Bill, the ultra bill that Chairperson was just speaking about now. And just to confirm that that bill has been referred to the specific committee on the 20th of January. So there's no doubt that the Standing Committee on Agriculture, Environmental Affairs and Development Planning will be dealing with the amendment bill. Thank you.
Honourable Maseko, I see Mr. Munro's hand is raised. Would you like him to go before you?
Yes, Chair.
Mr. Munro.
Chair, yes, from our side, I'd just like to state thank you very much from our side. And we would exit the meeting now with your permission.
Thank you very much, Mr. Munro. Before you leave, let me then just thank you for your inputs, and we look forward to working with you. Also, thank you for your support in providing us with the contact details of people that may be interested in making input into this amendment bill. But thank you very much to you and your colleagues for your presence, and I look forward to our next engagement. Thank you very much. You are free to leave, and with that, I want to hand over to Honourable Maseko again.
Okay, thank you very much, Chair. Tomorrow's meeting about the farm workers transport, I was just interested to hear from you that what was the response from the chair of the Transport and Public Works and their standing committee members, because I tend to believe the resolution was to have a joint meeting with them so that when we make the resolution, since it's another portfolio, it's become an ease of taking the resolution with their presence in the meeting.
Yes, thank you. Honourable, an invitation was extended via the chair of that committee for them also to join us tomorrow in the meeting. As we've stated previously, the rules don't really provide apparently for joint committees or joint meetings in that respect. But as we as colleagues obviously invite each other, as quite often we find that certain topics may affect more than one provincial department. So in that respect, an invitation was extended. Initially, the Department of Transport and Public Works indicated that they do not believe that they would be able to add a lot of value to the meeting. But then once they saw the agenda, they then also indicated that they would like to come to the meeting. And at this point in time, the link to the meeting has been communicated with them, and I expect them to be in the meeting, and they will be given an opportunity once we've had the presentations from those that we then invited first to come and address us, to also add their views in terms of tomorrow's meeting, because if obviously it should eventually spill over to traffic management and traffic regulations, then obviously that would be something outside of our ambit. And obviously it's not only the transport of agri workers that may be affected, but also the transport of any other groups of workers. As we all know, quite often people are being transported still on the back of open vehicles, so to say. Honourable Bartman, your hand.
Thank you, Chair. Chair, I just want to get clarity from the procedural officer on one matter, and then just another question. I saw on the briefing from the transport part of it from tomorrow that there are two specialists briefing us, and one of them I think is actually someone who's retired, and one is someone specifically from Stellenbosch municipality. And I wanted to find out, why is the Department of Transport not rather briefing us instead of just sitting in on the meeting, compared to two specialists, when one could argue that one could actually pick any specialist from any municipality, for example, and what deems that particular specialist the expert in that particular matter. And then I just want to find out procedurally, we made a resolution to ask for a joint meeting with Transport and Public Works. And I wanted to know, how does it work then now if we're just inviting them to join our meeting? Thank you.
Good. Thank you, Honourable Bartman. Regarding the joint meeting and the rules for that, I will leave to Ms. Nikat. In terms of who are going to address us tomorrow or present to us, two things. As I've indicated, when I approached the MEC for Transport and Public Works, the feedback via his head of department, I presume, I just received the message being forwarded to me, was that they, at that stage, indicated that they do not have the accident analysis capacity that I was looking for. My reasoning is that if you want to solve a problem, you must first understand the problem, or what is causing the problem. And if the provincial traffic department is unable to provide us with accident analysis statistics, then obviously we had to go and look elsewhere. So with them initially indicating that they do not see themselves attending this meeting, we went first to an experienced traffic officer. As you indicated, he was a senior officer, retired now, but somebody with many years of experience. So that was the reason for inviting Mr. Kenny Africa to address us, as you will see in the agenda, on the regulations, on traffic laws. I just needed somebody to come and explain to us what are the regulations, that apply to people that want to transport people on our roads. And then secondly, I, as a former councillor of Stellenbosch, happen to remember that Stellenbosch municipality, which is also situated in an area where lots of seasonal workers are transported daily, that they do have or used to have accident analysis experts, which was a capacity that I was looking for. And it seems to me as if not all municipalities do have accident statistics and are analyzing accident data. And in this respect, Stellenbosch municipality then indicated that they apparently still have that capacity, and that they would like to, or that they are willing to share that information with us as a committee. Again, just in terms of the joint meeting, Ms. Nikak, perhaps you can just share with the meeting what you've shared with me before.
Thank you, Chairperson. Yes, our rules allow for one committee to confer with another committee, and in this case, the way of conferring was in the fact that the chairperson of this committee then wrote a letter to the chairperson of the Standing Committee on Transport and Public Works, inviting the committee to participate in the discussions of the proposed meeting that's going to happen tomorrow. As far as the Department of Transport and Public Works is concerned, Member Bartman's question, what I did was I sent a save a date for the 10th of February to the department, just outlining what would be needed at the committee meeting and when it would take place. And specifically on the request of the chairperson, requesting statistics on accidents involving trucks transporting farm workers, statistics around that, and also statistics, what time of day do these accidents occur, and so forth. And the response from the Department of Transport and Public Works was that they are not in a position to assist the committee. And I think the chairperson just explained what the route was that he then decided to follow. And then the Department of Transport and Public Works actually referred the committee to the Road Traffic Management Corporation to say that they are better placed to assist. And in light of that, the chairperson then followed the route that he's just explained. I hope that answers the question, Member. Thank you, Chair.
My apologies, honourable members, I was on mute. Honourable members, thank you very much. I therefore want to say thank you very much for your participation in this meeting today. Thank you very much also for your interest in tomorrow's meeting. As I've said, we will have a slightly different composition with Honourable Marais coming in with his agriculture hat, so to speak. And with that, honourable members, I want to say thank you very much. This meeting is now adjourned.
Thank you, Chair.
Thank you, Chairperson.